behind closed doors, the truth always leaks out. And today, the cracks in Blake Lively's lawsuit are no longer whispers. They're shattering headlines. Wayfair just fired back with a brutal takedown, exposing every weak spot in her case, from missing legal papers to timelines that simply don't add up. What if the star power wasn't enough to keep this lawsuit alive? What if the truth burns brighter than the Hollywood spotlight? Stay locked in, because what you're about to hear will change the way you see this case forever. What if the motion everyone ignored just swung back like a sledgehammer? If you were wondering whether Blake Lively's letter motion yesterday, basically telling the judge, "I need more time because you have to deny this, because I said so," would stall the motion for judgment on the pleadings, where Wayfair is trying to wipe out most of her case, our favorite scorched earth attorney, Kevin Fritz, is back with a punchy response that hits hard right away, tearing into her points. We don't know how the judge will rule, but he lays a solid base and makes a strong plea to the court. He says a party can move for judgment on the pleadings after pleadings close, and that it's a valid way to challenge a failure to state a claim. It isn't waived until the close of trial, so it can happen at any time. As I've said, Ms. Lively wrongly claims the Wayfair parties sat on their motion for nearly 9 months, and that hearing it now would create duplicate briefs and waste the court's time. Remember how I mentioned she admitted she amended her complaint? They go there first. Her operative pleading wasn't filed 9 months ago, but 2 months ago, after the court tossed her claims against Jed Wallace and Street Relations. Ms. Lively didn't have to amend, but she filed a second amended complaint on July 30th, 2025. When she replaced her older pleadings on July 30th, she knew the Wayfair parties didn't have to answer for several weeks, and only after those answers could they move under Rule 12C. She even recognized at a July 30th hearing that they might do exactly that. If she's now not ready to oppose, he says that's on her. But what happens when the right to sue paperwork, or the lack of it, becomes the center of the fight? Imagine building a lawsuit on a door you never actually unlocked. There was debate about the CRD because she said she amended it, and a big problem sits in a footnote that they barely touch because it doesn't really matter. Under federal law, to sue under Title VII, she needs an EECC right to sue notice. Blake's complaint doesn't attach any CRD documents. To sue in court, her complaint must show the date she filed with the California CRD to prove it's timely and include a copy so the judge can confirm that the names on the right to sue notice match the people and entities she's suing. She did neither. In her first complaint, filed after December 20th, 2024, she included "It Ends With Us" movie without any right to sue them. She didn't attach the CRD complaint and didn't attach a federal right to sue notice. She can't fix that later without telling the court and asking to amend to add parties. She added "It Ends With Us" movie from the start, and changing it now doesn't cure the failure to exhaust administrative remedies. From the CRD, that's where this all starts. He tells the court that a judgment on the pleadings is proper when, even giving the non-moving party every fair inference, the non-moving party still hasn't alleged facts that make a plausible claim. Here, the motion asks for dismissal based on legal issues. The sexual harassment, retaliation, failure to supervise, and aiding and abetting claims under California statutes don't apply outside the state. And when state letters meet a New York courtroom, the map of jurisdiction gets even trickier. Can a California permission slip open a New York courthouse door? If you go to the CRD, you get a letter that lets you sue in California. If you file in federal court in California, you need a federal right to sue. Her letter didn't grant permission to sue California claims in New York. Blake tries to connect the dots by saying, "I have federal claims. That's why I'm here, and I have California claims from the same events, so you have jurisdiction." That, they say, isn't enough. They also argue she didn't exhaust administrative remedies for different claims against "It Ends With Us" movie, and that she didn't properly plead retaliation. They add that Ms. Lively's defamation claims are blocked by litigation and/or fair reporting privileges, and she didn't allege the underlying tort needed for civil conspiracy. None of this needs evidence beyond her second amended complaint and documents it references or depends on. She doesn't explain how the voluminous evidence she's found would even be considered in opposing the motion. Put simply, there's no need for her to scramble to gather discovery to fight a motion that points to flaws on the face of her own pleadings. Though she notes she might amend again, she doesn't explain why she hasn't already or why the court should allow it now. She's had multiple chances. First complaint, first amended complaint, second amended complaint. And endless amendments don't fix FEA claims that can't be in federal court. So if the court trims the case now, how does that reshape everything that comes next? What if one ruling today slashes the briefing you'd need months from now? If the motion is granted fully or partly, the number of Ms. Lively's claims drops. Even if parts survive and someone later seeks summary judgment, the case will be cleaner, with less briefing and fewer exhibits. That's the point of a Rule 12c motion. She also can't show this will delay a trial set for March 2026. Fact discovery is still open, no summary judgments have been filed, and trial is more than 5 months away. He cites examples where courts granted 12c much later than here, even after summary judgment motions or partial summary judgment rulings. He points out she and her husband filed many sanctions motions against the Wayfair parties and their counsel during discovery. They had to answer those while handling discovery. Now she says she can't respond because discovery is ongoing. He notes that granting her timing request would push briefing close to the summary judgment deadline before the court can narrow issues. He says the request should be denied. Then he raises changing the case management plan and scheduling order. When the judge adjusted the schedule on September 9th, the court moved expert discovery to finish on November 14th, but neither party asked to move the November 5th, 2025 summary judgment deadline, and no change was ordered. You don't run summary judgment while discovery is open. The dates need to line up. And just as the calendar tightens, a new theory of damages lands on the table. New damages math, new delays, or a new opening. He says fact discovery won't be done until October 10th. Last night, the Wayfair parties proposed revising the schedule and are waiting for Lively to respond. Opening expert reports on October 24th, expert rebuttals on November 7th, depositions of experts by December 1st, and summary judgment motions by December 15th, 2025. They argue there's good cause. It gives the court time to decide the motion, lets parties finish fact discovery before expert openings, and finish expert discovery before summary judgment. If most claims fall on the motion, the new schedule lets everyone focus on fewer issues at summary judgment or trial. Then, on September 30th, just 10 days before the October 10th expert opening deadline, Ms. Lively rolled out a new damages theory, alleged lost profits, and they need more time for their experts to analyze it. As long as the March 9th trial date holds, this seems reasonable. The only obstacle, they suggest, is that Blake won't agree. He also notes the requests for admission. These are supposed to narrow facts before summary judgment and trial. They were due by August 14th. In the joint request to tweak scheduling, no one asked to extend that, and no extension was given. Months after learning the deadline, and 6 weeks after it passed, she now asks to extend it. She doesn't explain why she missed it, or why future depositions stopped her from serving them, especially since admissions are meant to simplify facts. He asks the court to deny for lack of good cause. And then comes the harshest hit, the missing federal letters and a ticking 300-day clock. What if the very ticket into federal court was never punched? It's striking. She missed a deadline after often telling the court the Wayfair side was late or stonewalling. Now we learn she was supposed to serve requests for admission by August 14th and didn't, then asked for relief later. With experienced counsel, how do you file without the proper federal right to sue attached? So far, Blake Lively hasn't given the court a letter proving she has the right to sue. Wayfair only needs to show that when she filed, It Ends With Us movie wasn't on the right to sue. Once you sue off that letter, that's your one shot. Amending and adding someone later doesn't cure it because your case started on that letter. If you change it, you must tell the employer. The California right to sue letter says you must serve notice on the employer. If she fixed it and got a new letter, she had to tell Wayfair and the court, which is why they ignore that claim now. From day one, these claims were in trouble because of CRD and EEOC steps. Maybe she hasn't even shown an EECC right to sue. Her current California letter says she must file a charge with the EEOC herself within 30 days of the letter or 300 days of the last incident of sexual harassment. She never went to the EEOC because the last reported incident was May 2023, and by August 2024, the 300 days were gone. They could wait, and after August 2024, the clock made it safe for them. She chose to amend again, and now the scramble is of her own making. The hearing is set for tomorrow on this exact topic. I'll listen in and report back, though a ruling may not come right away. It may be taken under advisement. So, when the dust settles after the hearing, which claims still stand, and which never truly stood at all? The evidence is on the table, the deadlines are gone, and the missing paperwork can't be hidden anymore. Wayfair's counterattack doesn't just poke holes, it rips the foundation of Blake Lively's lawsuit apart, but the real question now isn't what she's lost. It's whether anything at all will survive once the judge rules. Will her claims collapse completely, or will a single thread of her case remain standing? Hit that subscribe button, because when the verdict drops, you'll want to be the first to know how this courtroom battle finally explodes.